welcome back. You're watching The Farm. Now, India Inc. has been waiting nervously for the notification of merger control regulations. These regulations will decide which deals have to file with the Competition Commission of India and how long the Commission can take to scrutinize whether a deal is anti-competitive or not. Now, the previous draft regulations were met with lots of negative comments from industry on how the thresholds are too low and the time available for scrutiny too long. The big fear is that once activated, merger control regulations could slam the brakes on M&A activity. An unwarranted fear, says the Competition Commission Chairman Dhanendra Kumar, as he prepares to release a new set of draft regulations. I met him at the recently concluded IBA M&A conference. Listen in to this exclusive interview.
I can say that we are almost in a situation at the moment that we are geared up to meet the mandate given to us under the Act. Section 3 and 4, which relate to anti-competitive agreements, and 4, which relate to the abuse of dominance. Right. They have been notified already under on 20th of May 2009, and already we are receiving a lot of references. Almost 24 of them are under consideration with us. Section 5 and 6, which relate to combinations, acquisitions, mergers, consolidations. Those notifications are with the government, and we hope they'll be coming soon. We are finalizing our regulations very, very soon, and we'll be ready for implementation of these provisions as soon as these are notified. But let me very quickly add this dimension here, that sometimes there are some misgivings about Section 5 and 6. But Section 3 and 4 and 5 and 6, they are an integrated whole of the Competition Act, because even if Section 5 and 6 are not notified, nothing debars from a potential competitor or a business rival or a third person to file a reference before the Competition Commission under Section 3 that this combination which is likely to come is really an anti-competitive agreement, or Section 4 that's creating a situation where there could be potential abuse of dominance. And the Competition Commission would have to look at it under the Act, and under Section 28 can look at the possibility of division if it's required. I hope it doesn't happen.
So I get what you're saying, that even though 5 and 6 have yet to be notified, the fact is that if any combination, merger, acquisition was to result in either an uncompetitive or anti-competitive situation or an abuse of dominance, you still already are vested with the power to investigate that. You spoke of timelines for the notifications and the draft regulations. Can you elaborate a bit further on will the draft regulations will precede the notifications,
Absolutely.
right?
No. It will follow the notification, but almost instantaneously.
So when is the notification expected? Do you have word from the ministry, and when can we expect the draft regulations?
Not really. We do not know yet when the ministry is going to notify, but we expect that this notification would be coming soon. And as and when this notification comes, then our draft would be ready. Now what we are doing is that these draft regulations, they are being placed on the website soon, after these are discussed and finalized in the Commission. And then we would invite comments from all the stakeholders, possibly in 2 weeks or 3 weeks. And after these comments are received, then we'll take them into account. It's a fairly transparent and consultative process. Then we'll notify them or keep them ready for notification. But they'll be notified only when 5 and 6 have been notified, not before that.
Okay, the draft regulation should be on your website in another week or 10 days? Is that the timeline we're roughly looking at?
About 2 weeks, let's say.
And the notifications for Regulation 5 and 6, when is that likely to happen? In a month or two?
I do not know. It's up to the government, but we hope it will happen soon.
Would soon mean a month or two, sir?
I should presume as much.
Okay, so it will mean a month or two. Let me go back to the staffing issue that you were talking about at the beginning. Can you take us through how many people you have manning the Commission? Because one of the bigger concerns was that do India's regulatory bodies have enough people to process deal flow at the pace at which the economy has been growing over the last 3 or 4 years? And if that was not met, that requirement, then the concerns of 210 days, etc., become even more heightened and hyper, right? So take us through your people position right now, sir.
Absolutely. Well, we are in the process of building up our capacity. We have already recruited a few dozen people already through deputation and so on. almost 50 of them so far, various professionals, either joined or on the way. The remaining, total sanction strength is 185, and we inserted advertisement for direct recruitment. The written tests have been conducted, interviews are to be held soon, and those people should also be in position in the next month and a half, and then we'll train them. So we hope that our recruitment and capacity building process would match the requirement of our processing. But taking advantage of this particular thing you said about the expectation of industry, let me mention that in our regulations, which will be on the website hopefully soon, we intend to introduce a system of two-track mechanism for processing, and there would be a fast-track mechanism process, whereby some of the routine stuff which is not causing appreciable adverse effect on competition within India, they could be cleared on fast track. The time limit would be given 30 days, but we'll try to clear it almost across the table or within a week or whatever. If prima facie it appears there is no appreciable adverse effect, almost 90 to 95% cases we hope would be cleared through this process, and remaining which would need a detailed scrutiny could go in for the other route, which would be the most, which can take up to 210 days, but we don't expect we'll do that. The forms would also be simplified for the fast track clearances, that route.
And you said the fees would be lower as well for fast track. Lowered.
That's what we are contemplating, but I cannot say anything at this stage because the regulations are under finalization. So let's hope. Just wait to see them.
Okay, I want to ask you whether the draft regulations will deal with 2 or 3 broad concerns. But before I do that, you have yet to reach the 185 strength sanctioned by the government of people. That was the main cause of worry, that if we don't have enough people in the commission, as has been the case often with India's regulatory bodies, that there are not enough people, and then therefore the fault rarely ever lies in the regulations or the rules. It often lies in the fact that there are just not enough people to process those cases in a speedy manner. So when will you reach the 185 staff strength?
As I said, we hope that in the next month and a half, we would have most of our people in position, and then we'll expose them to training both within India and outside. And therefore, by the time we are asked upon to take processing of these cases, we hope that all these people would be in position.
Okay. Tell me, if the draft regulations already deal with them, then I will not waste your time any further. I think one of the key issues that was the issue of the 210-day timeline, which you already told me you're going to fast track some cases. But there's also the criticism coming in that have you cast the net too wide? Are too many transactions going to be required to go through CCI approval? And in that case, even then having fast track mechanisms will not be efficient enough. Do you believe that there is a case for more exemptions? Do you believe there is a case for strengthening the de minimis requirements of any sort so as to weed out a lot of the transactions that would not require CCI approval?
I would suggest that you have a look at our regulations once they are out, because they would list out various categories which would be put on the fast track mechanism. We do not think that there is need or possibly it would be in the interest of industry also to have an exemption under the Act at this stage. So if all those cases are notified to the Competition Commission of India, and we could just look at it, and there is also a provision which we are introducing for pre-merger consultation. And in that process, it will be possible informally for the people concerned to come and talk to our experts, and then we would guide them about the procedures, that this falls and this does not fall. And there would be a variety of cases where we feel that that there is no need of going in for detailed scrutiny. It doesn't cause any appreciable adverse effect. They could be like acquisition of shares below a certain shareholding, could be 15% or whatever, or acquisition arising out of succession or will and things like this. Variety of acquisitions or acquisition of assets which is necessary in the normal course of business. Suppose a large company were to acquire assets like cars or typewriters or whatever it is, it's not required to be processed. So those are the kind of cases which can be straight away. I'm not saying that such routine stuff, but even the investment, the buying out of investments and the shares and so on up to a limit. Now those are the cases which could be straight away cleared, and I don't think that it is going to hurt anybody. On the contrary, it would be useful for the people to have this clearance given to them straight away across the table by Competition Commission of India, that they don't need
why should they even come to you if they are so obviously?
No, there would be provision for de minimis also. I mean, these routine stuff do not.
So not all kinds of transactions will have to come to you. Yes.
But altogether, I can assure you that this is the implementation of this regime would be found to be in line with what is existing in the rest of the world.
So you're confident that the new draft regulations, which will come out in a couple of weeks from now, will put to rest fears of this net being cast too wide?
I hope so.
Okay. The other broad concern that did come up in the conference that, and the session that you were chairing was the issue of what is the trigger event? How do you determine what the trigger event is? And in some cases, the trigger event, if defined thus by the Competition Commission, may not even lead to a transaction. So how early do you have to inform the CCR?
On the trigger event, I would request you to just wait for the
draft notifications. Okay. So the final point then I'll make, and again, there's a strong likelihood that the draft regulations will take care of this worry as well. But what is dominance in the sense that many of the participants in this conference were also asking the question, saying, can you define certain areas that you believe or certain parameters that you believe will constitute the trigger of dominance, so that companies know in advance that if they're going to cross those parameters by way of a transaction of any nature, that they are going to then fall foul of your rules and laws. Is that something that's been dealt with in the draft regulations as well?
See, if we wish to define dominance, you have to first define what's the relevant market.
Right.
And relevant market, within that relevant market, there could be situations of dominance. So every case has to be viewed
on a case-by-case basis.
Case-by-case basis, but the intention is very clear that unless there is a situation when there is an undertaking which can abuse its dominance to the detriment of the market, we won't like to step in. But again, I would say that at this stage, just wait for our regulations.
Well, that was Dhanendra Kumar, the chairman of the Competition Commission of India, in an exclusive interview to the firm. He's a man with a motto, quite literally. Here's his parting shot.
File, smile and go.